Evening all, evening Udita. Today, we welcome to our third CPD of the year 2022, securing your rights and mitigating financial consequences by utilizing the contract as a tool during present global economic condition, which is much important topic among construction professionals on these days. Before introducing today's invited lecturer, I have few important notices for our SLQS members. One, we Sri Lankan Quantity Survey Paternity Oman are planning to do our regular events throughout the year 2022. CPD, Vesak Dansala, Midsummer Night, The Hope, cricket match, volleyball match, and annual get together. Out of these, Vesak Dansala will be held on next 15th May on Poya Day, and we need your contribution to make it success. You can contact any of our committee members for your donations. In addition to these regular events, we are planning a special events from this week. You all know Sri Lanka is facing to an economic crisis, and our relatives, friends, and all Sri Lankans are suffering with various issues. Therefore, we Sri Lankan Quantity Survey Patentees are going to organize a fundraising program to provide essential medicines in collaboration with Sri Lankan Community Social Club. I will share more details once process is established. Please contribute to it as much as possible, which will save a lot of lives. Next, we are planning our next CPD in the second week of May. We will inform in advance about the exact date with registration link. Hope you all will join with it and get maximum for developing your subject knowledge and career. Final, all of you are very well aware that we Sri Lankan Quantity Survey Paternity is a wing of Sri Lankan Community Social Club. Therefore, your strength is indeed to Sri Lankan Community Social Club by getting its membership. For more details, you can log in to www.slcsc.com website, which will clarify every question related to its membership. Okay, let's start our third CPD of the year now. Today's session will be conducted by Mr. Udita Taranga, who has vast experience in the field of claims and contract management. Mr. Udita is a quantum and forensic delay expert who is actively working in field of alternative dispute resolution. He possesses years of experience in various building and civil engineering projects in the Middle East, Asia, and UK, with a wide exposure to different types of claims and numerous commercial and contractual matters. Then I would like to hand over the session to Mr. Udita Taranga to start and continue our third CPD of the year, securing your rights and mitigating the financial consequences by utilizing the contract as a tool during present global economic condition. Thank you.
Thank you very much for the introduction. This is the first CPD I'm doing for SLQS Oman. So some of you probably know me well, but for those who don't know me, so I'll give you a brief introduction. I'm presently working as a contracts and claims manager for Buhaliba Holdings Group, UAE, and also presently working as a claims consultant in preparation, defending, and evaluating construction claims. I'm also a quantum expert and a forensic delay expert, and actively involved and testified in arbitration and litigation, and involved in all forms of alternative dispute resolution. And I've been appointed by legal counsel as an expert witness in major construction disputes, and experience in both and also certified in contract negotiation, and actively involved in number of contracts, subcontract negotiations, and geographically the experience in UK, South Asia, and the Middle East. So with that, today's topic is about securing your rights and discharging your obligations during the tough global economic conditions and uh, uh, the present pandemic and the other economic challenges. So this will be our presentation outline today. We'll start our discussion with brief overview of the present global economic conditions, and then we'll move into the impact of those global conditions and the discussion of different remedies available for the stakeholders in the construction industry. Then we'll move on to the specific remedies of extension of time for completion and adjustment to the contract price by giving due regards to the Oman standard form of conditions of contract, the third edition and the 2019 edition. And then we'll be discussing widely used and widely misused clauses under the same contract. So although they are very specific to Oman conditions of contract, but as the Oman conditions of contracts are similar to FIDIC conditions of contract, which we widely see the people are misusing specific clauses. And then we'll move on to the force majeure clauses and the new Oman condition 2019 edition, as well as which is also there in FIDIC 1999. So with that, we'll move on to our first topic, which is the challenges that we are facing, economic and the other challenges we are facing right now. As you know, we are recovering from COVID-19 pandemic, and now that we are threatened with other set of events and challenges, circumstances, and while we are overcoming the difficulties of COVID-19, and some of them are also related to COVID-19, but some of them are some other external events. So the economies are still struggling to overcome these things. The countries are still struggling to overcome this. As a result, the economies are not performing as expected during the post-COVID-19 duration. So what are these events? Basically, the outbreak of uh, Russia-Ukraine war and the supply-demand imbalance caused by the COVID-19, which is a ripple across the different countries, as we are still experiencing, and a new COVID-19 variants spreading recently, and the physical and monetary policy issues of individual countries. Uh, well, the fiscal policies are basically related to the government policies of spending, as well as uh, the tax and other charges, and the monetary policy is basically related to central bank of the country regarding the credit and the money supply, as well as interbank offers and interbank lending and those sort of things. The interest rates. Because of these events holistically, which are still affecting globally, the countries are struggling with inflation, and in brief, the world slipped to a new era, new fresh turmoil with these new set of events. So these are the core of what we are experiencing right now: the inflation, the price increase, and the different commodities, and the fuel, and several other things. So we'll be discussing this further. But if you want to really go in detail through this economic constituents and those things, the best thing is to get a brief idea is the World Bank Group flagship report, which is quarterly published. The last publication is in January 2022, the Global Economic Prospects, which outline the status of the economies globally as well as in your region specifically. And if you look at the executive summary of this report, basically it outlines some of the issues that we are facing right now is the supply bottlenecks, and the developing economies are still struggling, and it is still remains substantially below the pre-pandemic trend. And the new Omicron new variants, COVID-19 variants, and the increased inflation and the high debt levels of the countries. So the countries are struggling to pay their debts and restructuring and to restructure their debts. So those sort of things. And well, they're expecting possibly there will be a hard landing of those economies in the near future. And another good source is basically the World Economic Outlook Update, which is published also quarterly by IMF, International Monetary Fund. And last publication also is in first quarter 2022 January, which also raised similar alerts on these aspects. If you see the mobility restrictions because of the COVID-19 variant spreads and the rising energy prices and supply disruptions, and more broad-based inflation and then anticipated, and then the slower than expected recovery in the private consumption. Holistically, if you see the impact of those things, as we see, like ascribes to individual events, for instance, like the supply demand imbalance caused by the recent Ukrainian and Russian war, like because it raised the cost of living as a basic commodities, and they record higher prices due to shortage of raw materials, because uh, many of the raw materials of the manufacturing industry is produced by Russia and Ukraine, and they're considerable. They share a considerable market capitalization of those things. And therefore, the sanctions raised on Russia, as well as export limitations due to war in Ukraine, they have caused this supply-demand imbalance. So there's a shortage of raw materials, and plus the increase of the freight charges, because, for instance, the Maersk is one of the biggest shipping lines, and they have stopped all bookings to and from Russia and Ukraine. And basically, there are shipping restrictions in the 200 miles radius of these locations where the shipping lines are not working. So the rerouting will be there, and the risk premium will be there. So eventually, it raises the freight charges. But remember, there is a previous increase of the freight charges after in the recovery duration of COVID-19, because the reason being like the post COVID-19 order backlog, because there is a recovery from the COVID-19 and there is a high demand of export items, so they which increase which was driving the shipping prices already during past few months. But this added some spices to the issue, and it further raises the shipping prices. Now, if you see, and it affects the commodity prices and all products, building materials all over the world. And plus, if you see the Canada and Ukraine is one of the biggest timber importers, which is affecting the timber supply also. And in certain areas of the world, specifically in Europe, there is a manpower shortage due to Ukraine war, because many of the laborers who worked, many of the laborers and staff who worked there, the Ukrainians, they were called on to fight for the war, and therefore there is a shortage. And the gas energy supply, the entire Europe depends on Russia for gas and energy supply. And finally, this everything, and also the steel industry is halted because overall steel prices are driven up. So finally, so this creates a ripple in the whole world. The overall increase in the prices, of course, the categories in, and they're cascading through the supply chain, and finally it begins to show up in the consumer level as well. So not only the building material, they have, all the prices are increased now. So this is the overall impact. And if you see now, for instance, certain countries are closing down and putting certain restrictions due to COVID-19, new variants that are spreading right now. So, for example, recent lockdown in the Shanghai due to this Omicron variants. And remember, the Shanghai is the third largest industrial city in China, which is nearly 3.8% of the China's national GDP. So overall, these are the things that is affecting right now the material prices, the performance of the parties, and so and so. So that's the brief of the economic outlook, and now let's move on to see what is the impact of the stakeholders of the construction industry. So by definitions of the stakeholders of the construction industry, I suppose to take all the parties into consideration, from the contractor, subcontractor, supplier, the owner, prime contractor, and the end user. But to make things easier, as I'm presuming that most of you are involved in either the contractors camp or the subcontractors camp or the employers camp, and you're representing those stakeholders. So I tend to limit my discussion on the impact on these stakeholders, not the end user specifically. Also, if you see, the impact on the end user is quite straightforward, not that not that difficult. Plus, we'll have to consider the sale agreements and the rental agreements in order to discuss these things, which I believe not the proper thing that you're expecting from this presentation. So we'll limit our discussion on the major stakeholders. So what is the impact on the stakeholders of the construction industry is simply increase of the prices of the building materials, and the performance of the contracts, subcontracts, supply agreements, it become either difficult or, as some says, it's impossible, and some argues it becomes impossible. And also the material labor shortages, and there is a delivery delays due to various factors. And in extreme case, the suppliers, subcontractors are basically, you can see them out of the business in within a weeks or 2-3 weeks time. And well, that's when in some instances the subcontractors whom we are working, and you may find him in another 2 weeks that is out of the business because of these issues. And sometimes the countries through their fiscal policies impose taxes, duties, and charges to keep their economies intact without going into default, or to avoid the hyperinflation. So these are also common. So well, if you are working for employer, contractor, or the subcontractor side, so you will already must have, you already must have experience few of those things, depends on the place you're working. So in this case, you would be wondering what are the remedies available for us in these occasions. So whether to relieve from performance, or to get some excuse, or to claim for additional costs. What are the remedies available under the contract? So let's look at the remedies available in these cases. for different stakeholders in the industry. So regardless of whom you're representing and whose camp you're in, there are basic things that you can do to manage the risk. One thing is you can absorb the risk of these things. The other thing, you can pass the risk to the contractor, subcontractor, owner entirely, and then they share the risk between subcontractor and contractor in a fair manner. So whatever you, for who for whatever party you're working, so this will be one of them will be your ultimate objective. So for the contractor and subcontractor, so what they're looking for is basically financial compensation or additional time for completion or relief from the performance and excuse and those sort of things. And the owners basically what they should be looking at is attempting to pass the burden of added cost to either to the contractor or to the end user, or if they adopt for the fair approach, they can agree for absorb the share. But sad to say this, they can agree to absorb or to share the entire impact. But sad to say, in this part of world, it is very rare to see the parties, the owner and the prime contractor is sharing the risk. But if you see the other part of the world, basically these things are quite normal. Like for instance, if you say if you're in UK or Sri Lanka or USA, or there will be provisions in the statute that if the prices are going up beyond a certain limit, and the contractor and the owner has to share the risk of the increased prices to a certain extent. And there are formulas of the world. But to begin with, in this part of the world, these things are quite rare, or it is impossible to see these sort of things. A good example is the close number. What is it? Close number 51.5, I believe, 5 last paragraph of the third edition of the Oman Standard form of contract, which says no claim of the contractor shall be admissible on the account of escalation of prices of material, labor, and fuel. So this is what we see uh, more frequently in this part of the world, where the the subcontractor has to absorb the risk, unfortunately. Well, the good or bad, like the argument is twofold actually, well, this is the reality. Well, if you're speaking of remedies under the remedies available for each parties, so these we can categorize into two different. Is basically the remedies under respective contract as well as the remedies under the law. The respective contracts, it can be subcontract agreement, it can be contract agreement, it can be the sales agreements, the rental agreements. So this is the respective contract that address the remedies. And the remedies under law is basically is the laws of the jurisdiction, which set out what are the excuse and remedies of each the contractor and the employer in each occasion. But well, today we'll be discussing extensively based on the contract, and that is also based on the Oman conditions of contract. We'll be less focusing on the remedies under the law, as I'm yet to be familiarized with the law of Oman. But I'll give you a very brief of the laws of different jurisdictions addressing the uh, uh, situations that are very similar to the present. And well, moving on, we'll first discuss with the extension of time for completion provisions in these two forms of contract. The old version, the third edition of 1981, and the like 2019 edition, revision 1 of the standard form of conditions, building and civil engineering, for building and civil engineering works. So, well, this is the provision of the old book, which is third edition of 1981. And before they discuss this provision, there is one thing important, one important thing that we'll have to remember. So remember the economic conditions that I have discussed already, which is the hyperinflation and the struggling economies, the freight charges increase, prices increase, the suppliers are bankrupt, the factories in China, they're halting the production, so the delivery delays. So all these consequences are resulted from favor events, which is basically, if you narrow down, that becomes also a post-pandemic, the COVID-19 new variants, and plus the Russian-Ukrainian war. So if you narrow down in this way, our discussion will be very easier, because these are the uh, the 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 most significant and exceptional global events or circumstances that we are right now the experiencing the impact of. Apart from that, there are some other events which are ascribed to the individual economics, like for example, the the near bankrupt situations of the countries, and the hyperinflation, for example, like in Lebanon, Pakistan, and Sri Lanka. So apart from these individual cases, we'll be looking at right now what is important to us, how the globally defined exceptional events are affecting our building, our contract performance. So if you keep that in your minds, it while we are discussing this, it makes my task easier, because I'm going to describe one of a few of these clauses, which is really important in to our case. Of course, there are many other clauses. If you read the two of these contracts, there can be many arguments, of course, but I'm not going into detail. And if you have any questions, you can raise this in the chat box, and I prefer at the end of the session, and I prefer to raise these questions in person. So moving on now, this is the extension of time clause of the old edition. Should the amount of extra or additional work of any kinds of any kind or any cause of delay referred to in these conditions, or exceptionally adverse climatic conditions or other special circumstances of any kinds whatsoever which may occur, other than through a default of the contractor, be such fairly entitled the contractor to an extension of time for completion. The engineer shall determine the amount of such extension, and the engineer shall consult and provide the employer detailed written report before his decision to extend the completion date. And if you carefully look at the criteria for extension of time, here it is very clear, and it addresses the amount of extra or additional work of any kind, which is a very broad description of the extra or additional works, but we'll not be looking into this. And any cause of delay refers to these conditions, and maybe there are some applicable clauses under the changes in the legislation, but we'll look at that later. And the exceptional adverse climatic conditions, which does not in any way relate to our case, and the other special circumstances of any kind whatsoever which may occur. Wow, this is on the face of it, it seems broad definitions of the special circumstances. So what usually, I'm not sure whether these sort of things are discussed in the industry in Oman, but Well, on the face of it, it is seen as a catch-all provision to put all the claims of the contractor which is not qualified under the above criteria. So these special circumstances. But is it really? So the special circumstances, if you see, like in the concise Oxford Dictionary, with the word special is defined as like kind of peculiar, and they're not ordinary, uh, and exceptional in amount, in the amount and the degree, and something like that. So the special is it's not something ordinary, and exceptional in the amount and the degree and the occurrence. So, well, if you consider this, now it is apparent that you cannot put all your claims under this provision of special circumstances, because it has certain qualifications. But however, I'm pretty much not sure how the any kinds of whatsoever which may occur well, it's sort of diluting the strength of the special circumstances. But still, if you can qualify your the pandemic, as well as the outbreak of war under this criteria of extension of time. And also, it is not clear to me why, other than through a default of the contractor, is only limited to special conditions, whereas it should be common to all except this exceptionally adverse climatic conditions. And that's well, that basically serve the purpose. And if you're working for a contractor, so you can easily rely on this for if there is anything that is affecting your performance, whether your subcontractor has gone bankrupt, his factory in China has been closed for certain reasons, or if his factory is in Ukraine and it has been like destroyed due to war, and you can rely on this provision. But before I go further, I have noted certain thing in this clause. Basically, well, you have to follow the procedure aspects of these clause as well, where it's like it says the provider and the engineer is not bound to take into account any extra or additional work or other special circumstances unless the contractor has within 28 days given the uh, full detailed particulars of any extension of time, which may consider himself entitled in order to such submission may be investigated at the time. So, there is a strict preconditions of recovery of extension, a claim of extension of time or relief from the performance, is that you have to give the particulars, as well as you have to give the particulars under this clause, so within 28 days time. The clause is not an effective time bar, but still it's better to comply with the provisions of the particulars and the notices which is specified in this clause. The other thing is, the clause says provided that the engineer's decisions of the engineer's decision of the engineer regarding extension of time shall be final and binding. But I'm not sure why it has mentioned like that, unless there is a provision which directly empower the engineers this decision as a final and binding decision, so you can go to court and enforce this. And otherwise it becomes a meaningless, as if you see under 67, the arbitrator can always review and open up the engineer's decision. Plus, if the engineer has to make another decision under 67 regarding, could be regarding the same uh, the same aspects. So if the engineer is decision is final and binding under 44, there is no requirement why the arbitrator open up this decision. Plus, I'm not sure to what extent that you can raise the same under as a dispute under 67, under clause 67. For instance, if the contractor disputed the engineer's decision, so there should be a proper way to raise the same matter under 67. And if you raise this under 67, then it says the engineer shall again consider his again engineer shall issue a decision under clause 67. So it's not so it seems not so final and binding as it is described in the clause. But there's but this is something additional which I found out while reviewing the clauses. So unless of course there is a direct empowerment by the statute to for any payment for extension of time. So this is the extension of time clause under the new book, the 2019 edition, which is very similar, quite similar to the FIDIC 1999 edition. So it says the contractor shall be entitled to subjected to clause 8.42, which is the notice provision under clause 22.1. And then yes, the previous determination and the clause 22.1, the notice of claims. Then subjected to these conditions, the contractor and plus the contractor having taken all reasonable and proper steps to mitigate the effects of such causes. And remember, here is here is a higher burden of mitigation. Now the contractor has to take all reasonable steps. The all reasonable steps means the higher burden of mitigation, not the ordinary burden of mitigation. So subjected to these three things, the contractor is entitled to extension of time for a variation and a cause of delay giving an entitlement to extension of time under subclause of these conditions, and the forces of nature which are unforeseeable or against which an experienced contractor who could not have foreseen, and then unforeseeable shortage in the availability of personnel or goods caused by the epidemic or government actions, and finally any delay, impediment or prevention caused or attributed to the employer and his personnel. Now, well, A is not related to our case anyway, and the B is quite related to us, as I discussed in previous case, the changes in the legislation. And the C, of course, which is mistakenly quoted it was quoted during the pandemic, of course. I've had similar cases where the parties tried to define the pandemic as a forces of nature, while it is not exactly a forces of nature. The forces of nature basically stand for the electric wind forces, the earthquakes, and the magnetic forces, and the like. So basically, the pandemic will not qualify for forces of nature, although it is unforeseeable. And which is related to our case is the unforeseeable shortages in the availability of personnel or goods caused by the epidemic or governmental actions, which is fairly within the scope of our case, which we can rely. So, but here's one important thing that you have to remember is you have the clause basically imposes a stringent requirement. And as I have mentioned before, one example, one requirement is to take all reasonable and proper steps to mitigate the effects of such causes. Usually it is reasonable steps, but here it is all reasonable steps, which means you have to take an extra step, an extra cost to mitigate the delays. And the other thing is this is basically the excluding contractor's right to concurrent delay. And here is under A, it says any delay which is caused or contributed to by the contractor. So the contractor shall not be entitled to extension of time if he has contributed. Of course, if he has caused the delay, is not entitled to out of the question. But if he has contributed to the delay, and this contribution has to be now further detailed and analyzed and investigations in an ideal case. And but however, it has been excluded from this. And the other thing is a concurrent delay, which will also lead to number of issues, because the concurrent delay can be, sometimes the concurrency can itself be a sort of arguments. We have had such cases where the definitions of the concurrent delay is argued in the arbitrations in this part of the world, because there is no such definition like in common law jurisdictions. So these are the things that you have to remember. And with these clauses, if we remain within the contracts, you will have to keep uh, proper caution in these aspects. And the other important thing, that's the substantive part of the claims. And this is the procedural part where the contractor has to issue the notification and the particulars and the detail and the interim particulars and the final claim notice. So here, basically, it says the contractor has to give notice to the engineer describing the eventual circumstances, and notice shall be given as soon as practicable and not later than 10 days. And the contractor shall also submit other notices which is required under the contract and supporting particulars for the claim. And the contractor has to submit, if it is an interim event, it has a continuing effect. The contractor has to submit interim claim and then further interim claim in a monthly interval, and plus a final claim after the conclusion of the event within 20 days after the end of the effects resulting from the event. So this routine has to be followed for the interim event, and for the detailed events, it is just well, you have to submit the detailed particulars within 28 days. But what if you don't submit? What if you missed those particulars and the notices? And here is the consequences. If the contractor fails to give a notice of claim and a detailed claim to the engineer, and send a final claim or final claim, if you miss any of those above, then the time for completion shall not be extended, and the contractor shall not be entitled to additional payment, and the employer shall be discharged from all liabilities in connection with the claim. But this seems to be a very effective time bar clause and the waiver of the right. So the contractor has to be aware of these procedural aspect of the claim, because if overlooked, so the whole right of the contractor can be waived or withdrawn. So the thing is, like, there are effective solutions under the prevailing law. There are certain arguments that can be made, which I've discussed during my past, but my past presentations. But now it is not within the scope of this presentation because it's a different subject actually. But there are remedies under the law, there are remedies under the contract itself, there are arguments that can be raised if you do not comply with these provisions. But before you go there, but it is important at the level of contract administrators, the claims managers, it is important that you comply with these provisions, and any argument thereafter may be reserved for the arbitral tribunal or the council that you're representing if you go to arbitration, or mean the mediation, or in the other forms of alternative dispute resolution. Because why? the contractors and the owners, the prime contractors as well as subcontractors, they tend to be very contentious is their proceedings. Nobody wants to hear the other argument, although your argument may be correct, but you have not complied with the contract. That's the end of the story. The other part is administering the contract. So I'm not required to go beyond any other arguments and the legal provisions and everything to consider for the sake of giving you your right, whereas the contract clearly says that you're not entitled to any claim or additional time, any claim for cost or additional time if you don't comply. So best to comply and reserve the arguments and everything later. And if you need this, if you need these claims to go forward, and you need to hire the claim consultant or expert in the field to argue on behalf of you. So this is a different aspect and a different subject. And then moving on to that's the extension of time part, and then moving on to the adjustment of the contract price and how it is to be adjusted in these occasions. Well, the increase of the material and labor prices in the due to inflations and the ordinary circumstances is out of the question, because as I've read before to you, the clause 51.5, which is clearly specifying that no claims of whatsoever nature due to increases of the fuel, labor, material prices. So that answers the question. And then we come to this provision, changes in the cost and legislation, where you might want to rely on depending on your particular case. The provision of the old edition seems quite broader than the new one. It's very straightforward, and the only thing that you have to demonstrate is the changes in the large wages drawn and allowances paid to the labor, and that has also resulted from the changes in any legislation promulgated after the date of letter of acceptance in the Sultanate of Oman. That's what you have to demonstrate. But when it comes to changes in the material, although it's very simple, seems very simple and straightforward, the demonstrating the changes in the material price is not that easy, unless of course you have agreed with the consultant, project manager, or the employer that the schedule of your deliveries and to show that uh, the the procurement of these material, the delay of this procurement of these material until the time of higher prices is necessary due to some reason. So this change of the material price, if you can demonstrate with an evidence, and this is the day that I was expecting to raise the procurement, and I could not have made it prior to that date, and I could not have made it later to that date because it will affect time for completion. And however, I raise it in this date, and that affect the my contract price because of there are certain changes in the legislation. But this situation it becomes more complex if you are in and if you're performing during extension of time, the extended duration, if you're performing in an extended duration of the project. So that is about the clause 70.2, which is okay. But when it comes to the new version, 2019 version, this adjustment for the changes in the legislation is it's not that straightforward, and there are a number of conditions that are specified before for you to recover this the additional cost of increased prices. So here's the thing, like the one thing that you have to remember state that there was a change in the legislation that is made after the base date, which is directly affected the contractor in the performance of its obligation under the contract. And however, to the extent that these changes, the prices in the Sultanate of Oman of a product and that is fixed by the operations of the law and not subsidized by the government or Sultanate of Oman. So you have two conditions. So the product that you're claiming, and as is change due to the changes of legislation, it should be prior. It should be fixed by the law prior to that, and or either it or it should be subsidized by the government of the Sultanate of Oman. So that's a one condition. And the other thing is for the wages. Now that it should be the changes to the minimum wage in the Sultanate of Oman. So not as broad as previously in the third editions. Now you have several conditions imposed upon you prior to recovering this cost. Now if the contractor suffers or will suffer a delay, and O will suffer in the sense like it's in the prospective looking. The additional cost as a result of these changes in the law made after the base date, the contractor shall give the notice to the engineer, and then shall be entitled to extension of time for completion, as well as additional cost shall be included in the contract price. Well, after receiving this notice, the engineer shall obviously proceed in accordance with subclause 3.5 determination. Well, moving on now, let's discuss the widely used and widely misused risk provisions in the same contracts, respectively third edition and the 2019 edition. The the widely misused in the one which was during the pandemic is the employees risk, which specify there are certain risks to be there are certain risks that are employers risk, which the list goes on to define from A to H the set of events. Sometimes you may incline to rely on these things while you're reading through your contracts. If you're representing, if you are a contractor, well, you are inclined to sometimes use these provisions for your relief for the contractor. And many of the thing like if you see or the clause holistically, obviously there's a war hostilities, it catch your attention. And then of course like the operations of the forces of nature, which is of course which was of course widely used during the pandemic. But one thing you have to remember, this clause does not it has no resemblance to our situation. So it does not help us much. Why? Because if you read subsequently 19.4 consequence of employees risk, it says if and to the extent that any of the risk listed in the subclause 19.3 above results in a loss or damage to the works, goods or contractors document. So now there is a criteria. If you before you go further to number 2 of this 19.4, now you have to establish the works has been damaged and the goods or the contractor's document has been damaged due to whatever the event that you are relying on, that whatever the event you are claiming from. Now, then you realize, of course, none of the events that we discuss can possibly cause damage to the works. Oh, let's take a pandemic, new COVID-19 variants. So they cannot possibly make any damages to the works. So they cannot make any damages to the goods or the contractor's document. So, so with that, we can simply identify this clause has no reference to our case as it is. So with that clarifications, we'll be moving on to discuss the force majeure clauses, which is also widely used. Well, correctly sometimes and incorrectly sometimes. Why is that? Because there is no single definitions of the force majeure in the world. If you see across the different jurisdictions, the term force majeure is defined in a different manner. If you see in different contracts as well, in different forms of contracts as well, the force majeure is defined in a different manner. So the term force majeure is very common, is there in FEDIC 1999. But because of using FEDIC 99 in civil law jurisdictions, where the force majeure is defined under the law, there are cases where the some parties used to define certain events as force majeure, where the other party object this. For these reasons, actually, they have to change their definitions of the force majeure, the term force majeure, uh, uh, into exceptional events from 1999 to 2017, and that's a different story. So, well, let's look at some of the jurisdictions which defines term force majeure. Well, force majeure. So, let's look at let's look at certain definition in different jurisdictions, and this is from UAE Civil Code. This is from UAE Civil Code, which is Article 273 of Law number 6 of 1985, UAE Civil Code, which says in contracts binding on both parties, if a force majeure supervenes, which makes the performance of the contract impossible. And this is where the arguments comes usually. Some people tend to argue that in order to qualify as a force majeure, it should be an impossible event. And where the some parties who's relying on the FEDIC wording on the 1999, which says basically, well, there is no such impossibility, and that's true. So the Article 273, which is addressing the force majeure and UAE in UAE, and moving on, and then well, this is a Quebec Civil Code, Article 1470. Force majeure is an unforeseeable and irresistible event, including external causes with the same characteristics. And moving on, and this is from German Supreme Court, which describes the force majeure, an extraordinary event which affects the business from the outside, which is unforeseeable, which cannot be prevented, and even applying the utmost care without endangering the economic success of the enterprise, which also has not been taken into account and be put out with the contractor due to its frequent occurrences. Now, whatever the force majeure provision you're looking at, you might have seen some common scenarios, which is basically the unforeseeability and the exceptionality and extraordinary nature of the event, and the cannot be prevented by putting the best efforts. So irresistible event, so, and has some external characteristics. So these are common things in force majeure, which is of course inferred, which are the criteria has been inferred in draft FAD clause as well. So this is from the French Civil Code. There is a force majeure in matters related to the contract when an event beyond the control of the debtor, which could not reasonably have foreseen at the time of conclusion of the contract, and could not be avoided by appropriate measures, and prevent the performance of the obligation by the debtor. If the impediment is temporary, and that's a different scenario, temporary impediment and the temporary impossibility. So the basic thing is it should be beyond the control and external events and impossibility, and the performance should be prevented. And this is why there is a conflict between FIDIC, whereas the FIDIC, it has no such requirement. It does not specify all such requirements. But if you see in the United States of America, which is very different to the approach of the civil law countries, and now the related the doctrine is the doctrine of frustration, and the frustration required the higher burden of uh, it requires the highest burden and the highest standard. So usually normal exceptional event cannot qualify in the frustration. But in USA, for instance, they have a doctrine for temporary frustration and temporary impracticability, which is section 269 of the restatement of contracts. And in common law jurisdictions, ladies and gentlemen, there is no force measure defined under the law. If you see in England and Wales and Australia, Ireland, and in certain with the certain of course changes in the USA, and there is no specification for force measure. And the related doctrine is frustration, and the frustration will occur when an unforeseen event occurs after the contract is entered into and it is outside control of the parties, and which make the contract it is physically or commercially impossible or illegal to perform, which is the higher burden, which is a higher qualification as a higher standard. Now you need to qualify this to the frustration and transform the performance of the contract into something so radically different from the intended purpose that it would be unfair to hold the parties to their obligation. When the frustration is alleged, when the frustration is called, and now it is the frustration is plead, now the parties are released from the performance, and that's the frustration, and that is the doctrine under common law jurisdiction. If you are working for a common law jurisdiction, what is force majeure is limited to what is defined in the contract. So let's take for instance to UK, and let's take your Oman conditions of contract to UK. Well, in that case, the force majeure, which is defined under clause 21 in the new book 2019 edition, is the force majeure which is agreed and defined by parties. So there is nothing else. Unless, of course, the laws of Oman define force majeure. So let's focus on this clause, because this clause also has been used during the pandemic and has been argued by different parties in different in different times. So, and I also have been involved in such case, so which is quite similar to this FIDIC form of contract with certain amendments. And then I, like with my experience, I wrote an article about the FIDIC force majeure clauses, which you can see here. If I will send it to you with my presentation in due course, this article. So describing critically the and commenting on the clause 19.1 of the FIDIC 1999, the force majeure clause in light of the pandemic. Well, this has been prepared in 2020, but I'm sure some of these the comments are still related. You will find it related to your case. So starting with the certain criteria under force majeure clause of FIDIC 1999, which is at first beyond, it should be beyond parties' control, and it should be such that party could not reasonably have provided against before entering the contract, and which having arisen such party could not reasonably have avoided overcome, and which is substantially not attributed to the other party. Well, I have described these four criteria in detail and all in the short article. Well, if you read carefully, you will see there is no test here for unforeseeability, and the test is basically the party could not have reasonably provided against before entering the contract, which is quite different if you see in the point of law. And then it goes on to define the events from A to D, and A, war, hostilities, invasion, and B, C, D, and E. So the purpose of the list is sometimes also argued, because if you read the clause 2, it says 1920.12, it says force major may include but not limited to the exceptional events such as B. So it seems to me that it gives some sort of the impressions on the commonality of the events. Whereas, see, you might have an event, for example, pandemic. The war is clear. The war is clearly specified here, so there's no question. But the pandemic, if you say there is no specification for the pandemic here, so you cannot even consider it under natural catastrophes, as because it's really not. So if you carefully read these four, you can see the pandemic qualifies for A, B, C, D, but it is not common with the events described in A to E, because the pandemic, certain aspects are missing from the pandemic for you to qualify this under similar and the similarity for A to D. So this is a sort of question which were raised by the contract administrators during the pandemic, and we had experienced number of such arguments back and forth. Well, if you want to rely on this clause, yes, you can rely, but it's the matter of argument, and it depends also in the jurisdictions where you're working on. And the thing is, like, some people argue if the parties or will be prevented from performing of any of obligation is basically the qualifies as a prevention principle, but it really not. It should be qualified as the impossibility of performance, which is really not, because it says the prevention of performance of any obligations, which is the any obligations in the sense which is uh, which you can qualify the time for completion obligation, which means the contractor is prevented from performing his time obligation, which means basically the extension of time claim. So there is no impossibility of performing the contract, but it is a performing of obligation instead. So there is obviously the duty for notification, and then of course there is a duty for no duty for mitigation. So there is an extension of time as a relief, and there is a cost if this events, and I believe it should be under 221.1.2 and not 20.1.1 if the event or circumstance described in subclause 20.1.1 occurs in the Sultanate of Oman for payment of any such cost to the event extent that they are not indemnified through the insurance policies. So ideally, it should be referred to these events. I'm not sure why it is sorry, these events. So with that, ladies and gentlemen, the final note of caution that you need to be very much aware about the clauses that exclude your entitlement for EOT when there is a concurrent delay, which is a very clause that we discussed under new edition 2019, clause 8.4. And the clauses that exclude the prevention principle. Basically, the prevention principle says if the employer is prevented from performing the other party, he cannot eventually relying on levying any damages on the contractor. But this principle can be excluded by agreement. The clauses that assign the burden of all residual risk to the contractor. For example, the clause that says like the all other risk apart from the employer risk are the contractor's risk, and the strict time bar clauses linked to notices, particulars, and claims, which is very similar to what we have discussed. And the clauses that has no link with the the entitlement and the claim clauses. So this can also become a really big problem sometimes. So with that, we will move on to the Q&A stage. Now, if you have any questions, you can raise them.
Udita, thank you very much for your wonderful presentation. Udita, the most common grounds that most of the contractors use to claim for the COVID-related costs are the change in law and the force majeure clauses. So hugely depend on these clauses during the pandemic. So the government used to issue various circulars. There could be various decrees. At the end of the day, when you have a close look into this, these kind of circulars are nothing but they are directives that are provided. So for the interest of the audience, what does constitute change in law if you are seeking a remedy under this principle?
Well, changes in the law in the sense, basically, the laws of the jurisdiction, the law is a defined term, but if you see the clauses that address the changes in the legislation, basically, well, it's not only really the legislation, but it goes on to describe what are the inclusions of this legislation, the laws or the decrees and the regulations and the so and so, those things. But if there is any changes in these things, obviously it can be recoverable. For instance, I would say the anti-dumping duty. So any changes in the taxation, any changes in the policies, and that also can qualify as the changes of the legislation, or need not necessarily be the legislation which address the basically the aspects that is not related to construction. So it's basically, well, it tends to interpret widely, not broadly. So that's certain benefits that is available for the contractor for these changes in the legislation. So if there is certain changes in the civil defense or the regulations or those things, so that also can qualify as a change in the law.
Right, thank you very much, Udita. Right, we'll allow our audience to drop in their Q&A. Please drop in your messages so Udita can respond to your queries. Thank you. Right, Udita, by the silence of it, I don't seem any queries or any questions presented from the audience. Right, so I think we can wind up today's session.
Prashant,
Sorry. Yep.
Prashant, with one question. So, as per your experience in Dubai, in UAE, is there any of the contractor get any entitlement for the cost based on this, change of law, by this referring that clause? Because no, in that, I mean, as far as I know, in the FIDIC 2019, I think 2020, I think they have, they have given one, I mean, kind of a guideline, that with the contractors can be, contractors party can be claimed for the cost only because of the change of law only. So in this base of this, that guideline, in UAE, as per your experience, if any contractors, have paid, or I mean, what kind of law changes they have referred to get that cost?
Well, if you're, it depends actually. I would say, like, if you're talking about any rules or decrees which is published due to the COVID-19, and because these cannot solely qualify as a change in the law, because if you see, for instance, I'll give a better example, is that, for example, like let's say, like there is there is the regulations published by the health authorities to labor, how to manage labor and those sort of things during the pandemic. But before you qualify these things as a change in the legislation, you have to go again and see that what is your the contract says about labor laws and prevention of pandemic. For example, in FIDIC 1999, as I remember, so you have an obligation to put in place the procedure to prevent the pandemic. So in that case, of course, your cost entitlement will be arguable. But when it comes to the changes in legislation, for instance, imposing on the tax and certain sort of duties and all those things, well, these things, of course, you can easily recover. So it really depends on why the change of the legislation has been imposed. So, and regarding what the changes of the legislation has been imposed. So, but in most of the case, it is recoverable. But why it is difficult, I'll tell you why. I would tell you why it is difficult, because the proving of the impact of these changes are difficult. So that's where the contractors would struggle to getting to pass their claim through. So not because of the entitlement. The entitlement is quite straightforward.
As to the one more question, that regarding in that new Oman Constitution Contract 2019 version, that you mentioned very clearly, for the concurrent delay, there will be no EOT, the granted.
Yeah.
But yeah, nothing is no. But okay, now only issue is something. But in that same document, the concurrent delay is nowhere defined. Again, I think in the 2017 version also, it is not defined very clearly what is the concurrent delay. That what are the parameters? So in case of any argument, the conductors, without knowing this one, if we sign the contract, or maybe there's the kind of dispute. So how the as per your experience, how the court or the arbitration will be judge the situation, since this is not defined.
Well, the concurrent delay is neither defined. I think, as you said, it's not in Oman. It is not defined. Neither defined in UAE in a greater degree of detail. Unlike in UK, for instance, there is a specific definitions for a concurrent delay. It should be an effective cause and with a similar causative potency. So this definition is not applicable in here much. But when it comes to concurrent delays, basically what the tribunal would look at is basically they would apply the common sense approach to find out whether, and plus if you don't have any definitions in the contract, basically the sometimes they tend to use the literal meaning of the concurrent delay, and sometimes basically they tend to approach this with common sense to see, for example, uh, let's see the my manpower on the side. For example, there is a modification for the LPG gas pipeline of the project, and same times my specialized contractor of LPG is not there in the site with his manpower, and the modification is going on, the LPG work is going on. But this is really a true situation of the concurrency and for the eyes of tribunal. And anything falls below that, the functional concurrency, and then the in the primavera, like usually the experts tend to come up with number of type of concurrencies, the functional concurrency, the parallel concurrency, those sort of things. So no, those things are not really much of interest for the tribunal. The tribunal will look at the facts and approach with the common sense to see whether this is truly concurrent. And well, this sometimes, of course, act in the favor of the contractor. But there are certain other provisions in UAE law, for instances, they would look at while giving effect to these sort of provisions, whether there is a substantial injustice to the other party, whether there, for instance, in a factual manner, rather than adopting the principles of the common law jurisdictions.
But that's it. Prashant, I think there's some question in the chat box.
Let me see. Could you share with us outcome of the evaluation of COVID-19 claim. So share with us outcome evaluation of the COVID-19 claim. Well, I'm afraid I cannot share the documents because they have sort of confidential nature. But if you want, I can give you a brief outline of how to evaluate the COVID-19 claim. So basically, in that the effect of the COVID-19 is either basically on the labor and the material delay, or these subcontractors goes bankrupt. So basically, in that case, you evaluate if the material delay, for instance, these things are really delayed due to COVID-19, whether the contractor has placed the order in a time before that shift to the pandemic. And there are, of course, some of the brief guidelines. But these guidelines I have addressed in detail in my previous presentations, which I can, of course, share with you with the SLQS email. And then
Any more questions?
There's a, I think, one question now asked by one of the, I think, ABC candidate. If an APC asks about the COVID-19, what should be the answer? Is it only time or time plus cost under FIDIC 1987?
FIDIC 1987.
Yeah.
Well, unamended FIDIC 1987 version, the COVID is only, I believe it's time only, because it only qualifies as the other special circumstances. There is no provision for cost. So yeah, because well, under 1999 you have some the arguments here and there, but I think it's out of the question in 1987. There is no cost entitlement.
All right. So with that note, it comes to the end of the CPD session organized by SLQS Oman. A big thank goes to Mr. Udita Taranga, who is conducting the CPD all the way from Dubai, and his contractual knowledge and his expertise about claim preparation and dealing with related matters have enlightened our knowledge and the betterment of our profession. So with that note, we would like to thank Mr. Udit Taranga for his valuable time contributed towards the betterment of SLQS Oman. And special thanks goes to Mr. Lahiru Idmalgoda, who did the coordination with Mr. Udita to make this occasion a success. So with this note, we would wind up today's CPD session. SLQS likes to receive your constructive criticism to develop our future CPD sessions, and we would request you to drop down an email or contact some of our committee members with your suggestions, so that we can take them on board to enhance our operations. Thank you very much for joining today, and until we meet from another CPD session of SLQS Oman, good night from all of us, and a blessed evening. Thank you very much.